I have been inspired by the founding fathers of our constitution that I should discuss about the nature of the constitution. Nature of the constitution first starts from utility of a historical retrospect. The very fact of the Constitution of the Indian Republic is the product not of a political revolution but of the research and deliberations of a body of eminent representatives of the people who sought to improve upon the existing system of administration. Makes a retrospect of the constitutional development indispensable for a proper understanding of this constitution. Practically, the only respect in which the Constitution of 1949 differs from the constitutional documents of the preceding 2 centuries is that while the latter had been imposed by an imperial power, the Republican Constitution was made by the people themselves through representatives assembled in a sovereign constituent assembly. That explains the majesty of the ethical values of a new instrument and also the significance of those of its provisions which have been engrafted upon the pre-existing system. Now I am discussing about Government of India Act 1858. For our present purposes, we need not to go beyond the year 1858 when the British Crown assumed sovereignty over India from the East India Company. The Parliament enacted the first statute for the governance of India under the direct rule of the British government. The Government of India Act 1858, 21 and 22, BICT C 106. This act serves as the starting point of our survey because it was dominated by the principle of absolute imperial control without any popular participation in the administration of the country, while the subsequent history up to the making of the constitution is one of gradual relaxation of imperial control and the evolution of responsible government. By this act, the powers of the crown were to be exercised by the Secretary of State for India, assisted by the Council of 15 members known as the Council of India. The council was composed exclusively of people from England, some of whom were nominees of the crown, while others were the representatives of the directors of the East India Company. The Secretary of State, who was responsible for the British Parliament, governed India through the Governor General, assisted by an executive council which consisted of high officials of the government. The essential features of the system introduced by the Act of 1858 where the administration of the country was not only unitary but rigidly centralized. Though the territory was divided into provinces with a governor or lieutenant governor added by his executive council at the head of each of them, the provincial government were mere agents of the Government of India and had to function under the superintendence, direction and control of the Governor General in all matters relating to the government of the province. B. There was no separation of functions and all the authority for the governance of India, civil and military, executive and legislative, was vested to the Governor General in council, who was responsible to the Secretary of State. The control of the Secretary of State over the Indian administration was absolute. The act vested in him the superintendent's direction and control of all acts, operation and concerns which in any way related to the government or revenues of India. Subject to his ultimate responsibility to the British Parliament, he wielded the Indian administration through the Governor General as his agent, and his was the last word, whether in matters of policy or in details. The entire machinery of administration was bureaucratic, totally unconcerned about public opinion in India. The Indian Council Act of, now I am discussing about Indian Council Act 1861. The Indian Council Act of 1861 introduced a grain of popular element in so far as it provided that the Governor General's Executive Council, which was so long composed exclusively of officials, should include certain additional non-official member while transacting legislative business as a legislative council. But this legislative council was neither representative nor deliberative in any sense. The members were nominated and their functions were confined exclusively to a consideration of the legislative proposals placed before it by the Governor General. It could not in any manner criticize the acts of the administration or to conduct of authorities. Even in legislation, effective powers were reversed to the Governor General, such as giving prior sanction to bills relating to certain matters, without which they could not be introduced in the Legislative Council, vetoing the bills after they were passed or reserving them for consideration of the Crown, legislating by ordinances which were to have the same authority as acts made by the Legislative Council. Similar provisions were made by the Act in 1861 for legislative councils in the provinces, but even for initiating legislation in these provincial councils with respect to many matters, the prior sanction of the Governor General was necessary. Now I am talking about Indian Council Act 1892. Two improvements upon the preceding state of affairs as regards the Indian and provincial legislative councils were introduced by the Indian Council Act 1892, namely that A, though the majority of the official members were retained, a non-majority of official members were retained. The non-official members of the Indian Legislative Council were henceforth to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial councils were to be nominated by certain local bodies such as universities, district boards, municipalities. B, the councils were to have the power of discussing the annual statement of revenue and expenditure, that is the budget, and addressing questions to the executive. This act is notable for its object, which was explained by the Under Secretary of State for India thus: to widen the basis and expand the functions of the Government of India, and to give further opportunities to the non-official and native elements in Indian society to take part in the work of the government. Now I am talking about Morley-Minto reform and the Indian Councils Act 1909. The first attempt at introducing a representative and popular element was made by the Morley-Minto reforms, known by the name of then Secretary of State for India Lord Morley and the Viceroy Lord Minto, which were implemented by the Indian Council Acts 1909. The changes relating to the provincial legislative councils were, of course, more advanced. The size of these councils were enlarged by the including elected non-official members, so that the official majority was gone. An element of election was also introduced in the legislative council at the center, but the official majority there was maintained. The deliberative function of the legislative councils were also increased by this act by giving them the opportunity of influencing the policy of the administration by moving resolutions to the budget and on any matter of public interest, save certain specified subjects such as the armed forces, foreign affairs, and Indian states. On the other hand, the positive vice of the system of election introduced by the Act of 1909 was that it provided for the first time for separate representation of Muslim community and sowed the seeds of separatism that eventually led to the lamentable partition of the country. It can hardly be overlooked that this idea of separate electorates for the Muslim were synchronous with the formation of Muslim League as a political party in 1906. Subsequent to this, the Government of India Act 1915, 5 and 6 GOVC 61 was passed merely to consolidate all the preceding governments of India Act so that the existing provincial relating to the Government of India in its executive, legislative and judicial branches could be hived from one enactment. Now I am talking about Montagu-Chelmsford Report and the Government of India Act 1909. The next landmark in constitutional development in India is the Montagu-Chelmsford Report, which led to the enactment of the Government of India Act 1919. It was in fact the amending act, but the amendments introduced substantive changes into the existing system. The Morley-Minto reform failed to satisfy the aspirations of the nationalists in India in as much as professedly the reforms did not aim at the establishment of the parliamentary system of government in the country and provide for the retention of the final decision on all questions in the hands of the irresponsible executive. The Indian National Congress, which established in 1885, was so long under the control of moderates, became more active during the First World War and started its campaign for self-government known as the Home Rule movement. In response to this popular demand, the British government made a declaration on August 20, 1917 that the policy of His Majesty's government was that of increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to progressive realization of responsible government in British India as an integral part of the British Empire. The then Secretary of State for India, Mr. E.S. Montagu, and the Governor General Lord Chelmsford, entrusted with the task of formulating proposals for carrying out the above policy, and the Government of India Act 1919 gave a legal shape to their recommendations. Main features of the system introduced by the Act of 1919, the main features of the system introduced by the Government of India Act 1919 were as follows. Diarchy in the provinces, responsible government in the provinces was sought to be introduced without impairing the responsibility of the governor through the Governor General for the administration of the province by resorting to device known as diarchy or dual government. The subjects of administration were to be divided by rules made under the Act into two categories, central and provincial. The central subjects were those which were exclusively kept under the control of the central government. The provincial subjects were subdivided into transferred and reserved subjects. Of the matters assigned to the provinces, the transferred subjects were to be administered by the governor with the aid of ministers responsible to legislative council, in which the proportion of elected members was raised to 70%. The foundation of responsible government was thus laid down in the narrow sphere of transferred subjects. The reserved subjects, on the other hand, were to be administered by the governor and executive council without any responsibility to the legislature. Second, relaxation of central control over the provinces. As stated already, the rules made under the Government of India Act 1919, known as the devolution rules, made a separation of the subjects of administration into two categories, central and provincial. Broadly speaking, subjects of all India importance were brought under the category central, while matters primarily relating to the administration of the provinces were classified as provincial. This meant a relaxation of the previous central control over the provinces, not only in administrative but also in legislative and financial matters. Even Even the sources of revenue were divided into two categories so that the provinces could run the administration with the aid of revenue raised by the provinces themselves, and for this purpose the provincial budgets were separated from the government of India, and the provincial legislature was empowered to present its own budget and levy its own taxes relating to the provincial sources of revenue. At the same time, this devolution of power to the provinces should not be mistaken for a federal distribution of powers. Under the Act of 1919, the provinces got power by way of delegation from the center. The central legislature therefore retained power to legislate for the whole of India relating to any subject, and it was subject to such paramount power of central legislature that the provincial legislature got the power to make laws for the peace and good government of the territories for the time being constituting that province. The control and of the Governor General over provincial legislation was also retained by the laying down that the provincial bill, even though assented to by the governor, would not become law unless assented to also by the Governor General, and by empowering the government to reserve a bill for the consideration of the Governor General if it related to matters specified in this behalf by the rules made under the Act. Third, the Indian legislature made more representative. No responsibility was, however, introduced at the center, and the Governor General in Council continued to remain responsible only to the British Parliament through the Secretary of State for India. Nevertheless, the Indian legislature was made more representative and for the first time bicameral. It was to consist of an upper house named as the Council of States, composed of 60 members, of whom 34 were elected, and a lower house named Legislative Assembly, composed of about 144 members, of whom 104 were elected. The powers of the both of the houses were equal, except that the power to vote supply was given exclusively by the Legislative Assembly. The electorates were, however, arranged on a communal and sectional basis, developing the Morley Minto device further. The Governor General's overriding power in respect of the central legislation were retained in the following forms. His prior sanction was required to introduce bill relating to the certain matters. He had the power to veto or reserve for consideration of the Crown by bill passed by the Indian legislature. He had the converse power of certifying any bill or any grant refused to be passed or made by the legislature, in which case it would have the same effect as if it was passed or made by the legislature. He could not make ordinances having the force of law for the temporary period in case of emergency. This is all about today's the historical background of our constitution. I shall come with the second part of the same in my second video. धन्यवाद, नमस्कार.